Welcome to the MyAZ Lawyers Law Firm podcast. We provide the right resources on criminal defense and family law so you can stay informed. The attorneys at MyAZ Lawyers have the knowledge and expertise needed for your case and will give you the tools to protect your rights. This podcast series is reviewed and approved by attorney Candace Callan.
In this episode, we'll explain the penalties for leaving a firearm accessible to a child in Arizona. Some people feel more comfortable and secure knowing they have a firearm if ever necessary for self-defense purposes. Some also have them for hunting purposes and may even use meat obtained from hunting to feed their families. But while firearms can be useful in certain situations, in others, they can be incredibly dangerous. An example of this is when a firearm is left unattended and eventually results in accidental discharge and serious bodily injury or even death. Gun storage is a crucial component of firearm safety, as it can prevent accidents like these. Not everyone keeps their gun in a safe, unloaded, and with the safety mechanism on. What happens when a firearm is left unattended, especially if it results in injury or death? Can it play a role in legal matters besides criminal cases? Keep listening to learn more about what happens to someone who negligently leaves a firearm accessible to others in the state of Arizona. In that sense, what is Arizona Revised Statute Section 133109? ARS Section 133109 is Arizona's law regarding unlawful sale or transfer of a firearm to a minor. Selling or giving a minor a firearm, ammunition, or a functioning toy pistol without written consent from the minor's parent or guardian is a Class 6 felony. The statute specifies that this law doesn't mandate firearm sales reporting or firearm registration. There is also an exception for instructors teaching a minor firearm safety, hunting safety, or competition coaching if the parent or guardian has given consent for the minor to participate in these activities. Now, let's break down the penalties associated with a Class 6 felony. Unlawful sale or transfer of a firearm to a minor is a Class 6 felony in Arizona. A felony is considered a more serious offense than a misdemeanor, which carries a maximum penalty of 6 months in jail in Arizona. A felony typically has a longer term of incarceration, higher fines, and more stigma surrounding conviction. For example, a convicted felony may have difficulties and setbacks while trying to find a job and rent an apartment after being released from prison. Felons will also need to complete probation after their release. The rules and requirements set forth for felons released from prison can often feel so restrictive that it's like being back behind bars. Arizona law provides that a defendant charged with a non-dangerous Class 6 felony can have their charges reduced to a Class 1 misdemeanor if the Class 6 felony sentence would be unduly harsh. This is unlikely to apply in a negligent firearm storage case, as providing a child with a firearm is an inherently dangerous offense. Additionally, this provision does not apply if the defendant has previously been convicted of 2 or more felonies. The minimum prison sentence for a first-time offense Class 6 felony is 6 months, and the maximum sentence is 1.5 years. A Class 6 felony has a presumed prison sentence of 1 year. If the defendant has a previous felony conviction, the minimum sentence will be 1 year, and the maximum sentence is 2.75 years, with a presumptive sentence of 1.75 years. For a defendant with 2 or more previous felonies on their record, the minimum sentence for a Class 6 felony is 3 years, with a maximum sentence of 4.5 years and a presumptive sentence of 3.75 years. All of these sentencing guidelines can be increased by aggravating factors and decreased by mitigating factors. Let's also take a moment to review the laws related to child endangerment. Child endangerment is treated as child abuse under Arizona law and is defined by ARS Section 133623. It occurs when an adult, not necessarily the child's parent or legal guardian, causes a child physical injury or places them in a situation where physical injury is likely to occur. Leaving a firearm unattended, especially around young children, can be considered a situation in which physical injury is likely to occur. This offense can be charged at a wide range of levels. If the defendant acted intentionally or knowingly, it is considered a Class 2 felony in Arizona. Additionally, if the victim was under 15 years old, it can be penalized using ARS Section 13705, Arizona's law for dangerous crimes against children. If the defendant acted recklessly, it is considered a Class 3 felony. If done with criminal negligence, it is considered a Class 4 felony. The lower the number for the class of felony, the more serious the charge in Arizona. A defendant charged with any level felony can expect a significant amount of time in prison and on probation, as well as the loss of some civil rights and rejection and difficulties due to having a felony conviction on their record. Finally, let's explore how civil claims work in cases of negligent firearm storage. Just because failure to properly store a firearm isn't a crime in Arizona doesn't mean that a gun owner can't be held civilly liable for damages incurred due to negligent firearm storage. If someone is injured or killed due to a firearm owner's negligent firearm storage, it could result in significant damages, like medical bills, future medical expenses, lost wages, lost earning potential, wrongful death, infliction of emotional distress, pain and suffering, and more. Additionally, negligent firearm storage could become an issue if the firearm owner is a parent in the midst of a custody dispute. While civil and family lawsuits don't result in jail time, they can come with significant debts if a judgment is issued in the plaintiff's favor. A defendant is not entitled to a court-appointed attorney unless jail time is on the line. Remember, if you have questions about penalties for leaving a firearm accessible to a child in Arizona, contact our experienced defense attorneys specializing in criminal negligence and more. Arizona's lack of gun storage laws doesn't guarantee a lack of consequences for gun owners who don't securely store their weapons. If you're facing criminal charges for events that occurred with your firearm, you need an effective legal strategy as quickly as possible. A skilled defense attorney can help protect your liberty, reputation, and status in your community when you have been accused of a crime. Our Mesa and Tempe criminal defense team is staffed by experienced negotiators with the skill set to bring your case to trial if necessary. Don't wait. If you have a hearing set on a criminal matter in the state of Arizona, begin the process of hiring a seasoned private defender from home and free of charge. Our lawyers offer free initial consultations by phone, which is when you will be provided with a quote for our unparalleled legal services. To schedule your free consultation, contact us at MyAZ Lawyers today at 480-470-1504 or visit us online at myazlawyers.com.
Thank you for listening to the MyAZ Lawyers Law Firm podcast. Facing criminal charges in Arizona is very serious and requires the legal representation and guidance of an experienced criminal defense attorney. At MyAZ Lawyers, we'll aggressively defend your case to the best of our abilities. Contact MyAZ Lawyers today to get a free evaluation and find the peace of mind you deserve.